Hey everybody, I'm back. Me, Albatross, with part 2 of the Wayne Richie lawsuit. Um, I am gonna try my best to get through it on this part. Can't make any promises because I'm starting to run out of time. I gotta go to work, but I'm gonna get through what I can. Worst case, I'll just come back later this evening and finish it. So, I'm gonna get through what I can. Okay. Now we go through defendant's principal proffered facts. The evidence that defendant offers in contradiction of Ritchie's claim centers around the first deposition of Ira Feldman, taken on July 30th, 2002. In the course of that deposition, Feldman repeatedly stated that he had never heard of plaintiff, would not recognize him if shown a photo of him, and had not administered LSD to him. Now, the question of the deposition: now, did you remember a deputy U.S. Marshal by the name of Wayne Richie? And then his answer was, never, 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 I never. If he walked in here now, I wouldn't know him. Feldman testified further that he did not even attend the Christmas party in the post office building on December 20th, 1957, at which plaintiff alleges he was dosed with LSD. The question: did you ever attend a holiday party over at the post office building? Feldman answered, no, I didn't, placing the final categorical stamp on his denials of involvement in the substance of plaintiff's allegations. Feldman states that he never even entered the press room of the post office building where plaintiff claims he was drugged. The question goes, and what usually occurred in the press room? Was that for press conferences? And Feldman answers, I don't know. I was never there. I was never there. You were never in that room. Never in that room. Defendant also points to an exchange that occurred towards the beginning of Feldman's second disposition, in which Feldman again denies any knowledge of or involvement with the alleged doping of plaintiff with LSD. The exchange between plaintiff's counsel and Feldman is somewhat meandering, and each individual question and answer could appear ambiguous if not read in context. And so the conversation is reproduced at length below. Question: and could you give us, to the best of your recollection, some examples of the things that you now recall that happened to people by giving LSD? And Ira Feldman's answer: people would become very hallucinogenic. They would see things that they shouldn't see. They had trouble walking. They had trouble eating. A lot of people threw up, and a lot of people passed out. And the questioner says, no, but I'm talking about your experience when you said it made people act like jackasses. And the answer was, yes, when they fell down, when they spit all over themselves, when they are like jackasses. Normal people don't act that way. Questioner: if someone acts like a jackass, would that be erratic behavior? And the answer is, it depends on what Webster says. I don't know what it is. And the question: and how about if somebody went out and held up a bar? This would be erratic behavior, wouldn't it? And the answer: nah, that would just be a drunken bum. Wow. He's calling a U.S. Deputy Marshal a drunken bum. Wow. The guy who admittedly drugged a bunch of unwitting victims. Okay, Ira. Okay. The question: or would it be a jackass? And the answer: nah, it wouldn't be a jackass. He would be a U.S. Marshal that got drunk and fell on his ass. That's what he would do. And the questioner: I see. And Ira goes on: he doesn't come under this cover here. The questioner: I see. You remember that situation? And then Ira goes, no, I don't remember that situation. But this last 2 or 3 years, it has all been your clients that got drunk. I don't remember the situation. I wasn't even there, period. Nobody I knew was there. He just got loaded and fell on his ass. And he pulled out a gun and he held up a bar. If you can beat that in court, be my guest. Questioner: and you know, as a fact, sir, from your position and expertise in administering LSD, that he did not have LSD. And Ira's answer: do I know? Questioner: yeah. Ira replies, I don't know. I wasn't there. I didn't hear about it. I didn't see about it until it came in the newspaper. God knows how long afterwards, and not for 15, 20 years later. I didn't know. No, didn't know a thing about it. It was only later, in Feldman's deposition, that he appeared to admit having administered LSD to plaintiff, and it is the discrepancy between Feldman's remarks at various times that forms the crux of this question as placed before the court. Then we get to the evaluation of competing claims. The principal difficulty in evaluating plaintiff's motion for summary judgment on the issue of his LSD drugging here arises from the fact that the plaintiff and defendant rely most heavily upon the same witnesses. Ira Feldman, the admitted CIA operative and one-time MK-Ultra participant, stands at the very center of this case. And the question of which version his story to believe forms the crux of this court's inquiry. On multiple separate occasions, during his first and second depositions, Feldman denied, under direct questioning, that he had participated in any drugging of Ritchie, or indeed that he had ever before seen or interacted with Ritchie. However, during his first deposition, Feldman denied ever administering drugs to unwitting suspects, a denial that Feldman himself and others have since convincingly refuted. And then they go back to the deposition. Questioner, Mr. Feldman, did you ever witness anybody slipping LSD to another person? His answer, never did. Questioner, did you ever slip LSD to another person? Answer, never did, never did. Questioner, did you ever slip LSD into anybody's drinks? And his answer, never did. Questioner, so that every time that you gave somebody LSD, Sidney Gottlieb was along? The answer was, nah, he wasn't along, but he most likely knew these people. Like the 13th chime of a broken clock. Oh, wait, no, we're out of his deposition. Like the 13th chime of a broken clock. The demonstrably incorrect statements in Feldman's first deposition cast doubt upon all those that preceded them. Feldman's denials at the beginning of his second deposition are no more equivocal. At the beginning of Feldman's second I'm starting to get tongue-tied again. Second deposition, plaintiff's counsel showed Feldman a transcript of an interview that Feldman had given in which he admitted to having administered LSD to numerous non-consenting individuals. Confronted with this evidence, Feldman lacked a compelling reason to continue to lie about his involvement with MKUltra, and could hardly perpetuate his denials with any semblance of credibility. It thus remains significant that, at least at first, he continued to resolutely deny ever having drugged Wayne Richie. By comparison, the statements that appear to implicate Feldman in Ritchie's alleged drugging do so only obliquely. Feldman compares Ritchie's psychotic episode to the actions of an LSD victim without stating positively and explicitly that he knew Ritchie to have consumed LSD. And they go back to his quote, Ira Feldman's quote, "You just back up and step back away and let them worry like this nitwit Ritchie. Let them have a full head. Like what happened? Like what happened with this nut when he got out and got drunk?" Identify Ritchie as an LSD victim by saying, "The bird, like this guy who saw snakes coming out, he deserved a stuffer." From having LSD administered. "He had 8 or 10 drinks and then goes out and gets a couple guns, tries to hold someone up." From the first moment of his deposition, Feldman undoubtedly knew that Wayne Richie was alleging that he had been drugged with LSD. Feldman might easily have assumed that Ritchie's drugging was a foregone conclusion. The only remaining question concerned whether Feldman had participated in that drugging himself. In fact, Feldman's first putative self-implication came directly after plaintiff's counsel had referenced a San Francisco Chronicle entitled "Good Guy Fails as Bad Cop," written in 1957 about Ritchie's attempted robbery. The nature of Feldman's subsequent remarks, whether the reference to Ritchie's robbery triggered an unconscious admission or merely induced Feldman to offer a needless and unfortunate comparison remains shrouded in uncertainty. Does it, though? Nevertheless, it is inescapable that other explanations beyond Feldman's guilt exist to explain his remarks. It is also noteworthy that on no occasion did plaintiff's counsel follow Feldman's allusions to Ritchie with more direct questioning, designed to pin down precisely what Feldman intended to be saying. The absence of such questioning certainly does not eviscerate the potential veracity of plaintiff's assertions regarding Feldman's admissions, but nonetheless, it leaves this court in the position of essentially inferring facts from sideways comments rather than explicit testimony. Plaintiff thus can hardly be surprised when this court finds it difficult to grant summary judgment on such grounds. Plaintiff protests that the obdurate behavior of defendant's counsel is to blame for his inability to ask such follow-up questions, and indeed the record of Feldman's deposition appears to support this contention. The most notable interruption came as Feldman appeared to be implicating himself in Ritchie's drugging for the third time. Okay, and we go back to the deposition. I think this is the third one. I didn't say anybody had suffered. The bird, like this guy, who saw snakes coming out, he deserved to suffer. He had 8 or 10 drinks, and then goes out and gets a couple guns, tries to hold somebody up, and then he waits. And then Ira's counsel interrupts. Mr. Feldman. Plaintiff's counsel. He is answering the question. I object to your doing that at a critical time like this. You have some nerve to interrupt that witness now. That's horrible. Ira's lawyer. He appears to be spacing out. The plaintiff's counsel. He is not spacing out. You may be spacing out because of the testimony he's giving. And then Ira's lawyer responds. The video will show it. Then plaintiff's counsel remarks, it sure will. Ira's lawyer, go ahead. Plaintiff's lawyer, will you pick up where he left off? Will you read it to him? And the lawyer says, we have been waiting here since. And then plaintiff's counsel, we are in the middle of an answer. And then Ira's lawyer, we have been sitting here since 1 o'clock this afternoon. At a convenient time, we will take a break. And then plaintiff's counsel, we had a break. The defendant's counsel, you tell me when it's convenient, but sometime between now and 4 o'clock. The plaintiff's lawyer, who do you think you are to interrupt this witness like that at a critical time? You know what you're doing. And then the defendant's lawyer, excuse me, I don't agree with you that it is at a critical time. Plaintiff's lawyer, you know, that's why you did it. And then defendant's lawyer, I don't agree with you. Plaintiff's lawyer, of course you don't. Defendant's lawyer, do you want the reporter to read it back? And then plaintiff's lawyer, please give him back his answer as he is giving it. And then the record's read. All right. And then the plaintiff's lawyer, do you want to continue? Ira says, no, that's it. That's all I remember. Plaintiff's lawyer, can you give us some instances when you were working with White about who should be drugged? And then Ira responds, no, I couldn't give you any instances at all. Plaintiff's counsel, okay, let's take a break. Plaintiff is correct that defense counsel interfered improperly with his attorney's deposition of Ira Feldman, and that these interruptions may have well denied the plaintiff the opportunity to solicit further valuable testimony. Nevertheless, plaintiff's counsel never pressed this issue. Excuse me, yes they did, by asking Feldman again if he had drugged Wayne Richie, and then pointing to his earlier testimony where he too again denied the charge. Feldman's potentially contradictory replies add to this summary judgment motion an issue of credibility. Feldman's more explicit denials of having drugged Ritchie cannot help but cast doubt upon his subsequent references to involvement in those same alleged acts. At the same time, this court allowed plaintiff to take Feldman's deposition twice precisely because new information had come to light, and might allow the plaintiff to elicit more useful or even more truthful information from Feldman. The circumstances present a conundrum for any fact finder tasked with determining which of Feldman's several conflicting recitations of history to believe. Fortunately, this task does not permissibly fall to the court at this stage. The court may not make credibility determinations in the context of a motion for summary judgment. Okay, guys, I'm sorry. I'm going to have to go and pick this back up where I left off. I got to go to work, but I'll be back this afternoon. Thanks for listening.